I'm here in lovely Kenosha, Wisconsin. This cold Sunday. But yeah, so it's good to be trying to make sure that everything that an innocent kid gets rightly acquitted. And sometimes it's always interesting who your allies are and who your adversaries are in that process. But I'll leave it at that for the time being. Hopefully, we get that done because he's innocent and he deserves to be acquitted.
Actually, this will be let's start with this. Of what you are able to publicly discuss, what are the updates? What's any information that you can publicly discuss? What's going on with Kyle? Trial starts next week.
Yes. So on Monday is going to be the government's Daubert hearing of the government's expert witness that they didn't discover until months after the deadline. They were supposed to produce that, as the judge made note of, in August. They didn't produce it until a couple of weeks ago. So in my view, they really shouldn't have an expert be allowed to testify, except maybe as a rebuttal expert. But we'll see what his testimony is. Mark Richards will be in trial, or will be in court to cross-examine him potentially. But the prosecution will preview what his expert testimony purportedly will be. The court may make a clarity. The court's already given some direction that Kyle Rittenhouse's expert will testify in all likelihood, based on what the judge has said. And that includes a lot of very helpful evidence. This is a very respected, well-regarded, law enforcement-oriented expert witness who said that what Kyle did was clearly and incontrovertibly in self-defense. We'll see if this government expert has anything to really rebut, because almost nobody who's looked at it concludes anything other than self-defense.
And in total fairness, if anyone thinks it's a partisan issue, even the New York Times detailed expose came to the ultimate conclusion, not a court of law, totally different, no standards of evidentiary hearing, whatever, but they came to the same conclusion. What did you say the name of the hearing was? A Dobson hearing?
Daubert. So it's after a United States Supreme Court case, Daubert. And what it is the judge is supposed to only allow expert testimony when the subject matter of the expert's testimony is beyond the ordinary understanding of the jury. The concern is that either you'll have someone who's not an expert try to pretend to be one, or you have someone testify as an expert where that's the province of the jury and is fully within their common knowledge. Here, how to handle these kind of circumstances or situation is not within the ordinary knowledge of the jury. So an expert would clearly be relevant, and we, the defense, properly identified him many months ago. The prosecution tried to sandbag, tried to hope to not allow any expert testimony because they don't want the jury to hear from a well-respected person who has witnessed this kind of incident many times before, these kind of issues many times before, and noted how extraordinary Kyle's behavior was. Kyle was very reluctant to engage anybody. He tried to flee everybody, only engaged in any degree of self-defense when literally at the last second. And if he'd waited a half second later, he'd be dead. Other people would probably be dead. And that's what the expert effectively testified to on our behalf. We'll see what their expert is. And then next Monday, November 1st, jury selection begins. And so I'm bringing in people from around the country to be of assistance on that, and believe what we will be able to be of assistance on that. And then on top of that, to their credit, a group of great defense lawyers have made themselves available to be advisory counsel throughout the trial. And this includes, sometimes you say this person has, written the book on something, when you want to say they're such an expert. Well, it includes people who have literally written the book on these issues. So many of them have offered generously to be available. That's a fantastic resource. And sometimes the only hurdle you run into are people who don't necessarily want you to bring such resources to the equation. But we will have those resources available, and it'll, of course, be up to Kyle to decide what he wants to do. But we want to make sure he has every option available to him, and he has the maximum available defense to him, because he's an innocent kid the system's trying to railroad.
So like an expert on self-defense would literally be the person who, if you take a self-defense course, tells you how to hold a firearm, how to approach a situation, how to diffuse a situation, when you resort to lethal force. It would be like effectively an instructor to that nature.
Exactly. And his testimony, people can already go look up, and you can see how impressive his testimony was. It was very, very impressive. The judge repeatedly referenced him by his doctor title. So it's not just your wife that is a doctor. And so it was excellent testimony. It was very thorough, very thoughtful testimony. What it is in Wisconsin, and in like most states, Wisconsin has some really good, robust self-defense laws. But issues that people don't often think about I recommend the book Law of Self-Defense by Professor Andrew, as I sometimes call him. Other people will know him from his web presence. He's also been on Tim Pool, like we recently were. He has also articulated why Kyle is completely innocent and was completely right within self-defense. But his Law of Self-Defense book is fantastic because he goes through every single state law. He goes through the variations of it, issues of provocation, issues of when you have to escape, issues of duty to retreat, when that's applicable, when it's not, when defending property does it matter, when defending a person does it matter, when defending a third party does it matter. And what you have here is a combination of issues in Wisconsin that really an expert benefits the jury to explain. In other words, when is this a reason? Because under almost all self-defense, there's an objective component and a subjective component. The objective component is what would a reasonable person do? And the subjective component is what was this person thinking when they did it? People often forget in the criminal context, objective reasonableness sometimes becomes a factor. It can never replace subjective reasonableness, but it's often an additional factor, and that's what you need an expert for. Why was Kyle's behavior objectively reasonable? Not only was it objectively reasonable, it was exceptional. I've talked to military people who said they couldn't have exercised that degree of discipline that this 17-year-old kid did. A lot of people would have lost it. I mean, you're being attacked, someone's trying to kill you. Easy to just all of a sudden, it happened in Iraq. It's happened in war situations. Mm-hmm. Kyle exercised extraordinary discipline and only exercised self-defense when it was absolutely at the last second. He really took a gamble with his life in so doing, but he was trying to preserve and protect life as much as he could.
I know we've discussed it before, but I think we have a lot of new people watching. So one question that people are going to bring up from a culpability perspective, he's 17 years old. Did he cross state lines with the firearm? Was he entitled to have it? And even if it is, hypothetically, take the culmination in abstractum, that would have been self-defense. But showing up to a bar fight with a gun, for example, does that not create an element of culpability that might haunt him at the end? Or create responsibility, legal responsibility?
Really what's happened in this case, and it's the reason why a majority of the people in Kenosha have incorrectly presumed him guilty, is the prosecution has done a very good job running hit pieces on him with false claims in court and false claims in the press. And so, for example, people believe that he crossed state lines with a gun. That never happened. People believe he wasn't legally entitled to have the gun. As the judge recently noted, that law is likely void for vagueness, because there's a reasonable interpretation that that law did, in fact, legally entitle him to have a gun. Most of the gun law experts that I've talked to agree that he was legally entitled to have it. At a minimum, if you could interpret the statute to say otherwise, then the statute's void for vagueness, which is a constitutional Fifth Amendment provision. Also, the analogous one under Wisconsin state constitution would also apply. So I think that particular charge will ultimately be dismissed by the court. And the only thing he's going to trial on is, did he intentionally kill anyone without self-defense? And did he engage in reckless endangerment without any privilege of self-defense? And it is the prosecution's burden to prove that beyond any reasonable doubt. And there's what's called provocation and escalation. But here, what took place is all the evidence of provocation was on the side of the other people. He wasn't trying to provoke anybody. When he's running by people, he's saying friendly, friendly. These people that were trying to ambush him, including one of the people that was shot that night that chases him, was waiting in the cars, waiting to ambush him. He comes by, he sees him, and the kid is so innocent. He goes, friendly, friendly, all good. He doesn't know they're there to try to kill him that night. That's who he is. So he brought his medical kit with him, was trying to even treat the guy that he shot. He turns around, he's like, and then he sees a local Daily Caller reporters. They're treating him. He's calling, trying to figure out what to do, how to get help, when a bunch of people rush him and try to hurt him and ultimately try to kill him. One of the people attacks him with a skateboard. People should look at how physically heavy and strong as well. We know from visiting Tim Pool, skateboards are not small little things.
Anybody who's ever skateboarded would, it's no joke, and it's not to be glib. They hurt, they're sharp. And I actually knew someone in high school who got seriously beaten with a skateboard and was in the hospital for a week.
And they were swinging at his head. It wasn't like they were going for a knee. They were swinging at his head. And then the other guy pulled a gun and later told a buddy of his the only thing he regretted was not putting a bullet in Kyle Rittenhouse's head.
That was my next question. So that apparently was a Facebook post. Do we know if that Facebook post or those statements are going to be admitted as evidence, or are they now, or does that come via cross-examination of the victim, the witnesses?
The via cross-examination. And so like one of those people brought suit against the city of Kenosha. It's frankly a frivolous lawsuit. There's no grounds to it. These were rabble rousers. These were troublemakers. These were outside agitators, many of them from far away as Seattle and Portland. This was reported by other liberal YouTube press at the time that was from Kenosha. People who lean left, who are like, these people are not from Kenosha. And that was the case. Many of them had a criminal record as long as my arm or could keep going. Many of them were actual convicted pedophiles. Yeah. And I think if you look at Kyle, a kid with big eyes, you can get a sense of why these criminal sociopaths targeted him that night. He was there trying to put out fires. He's there. He was all the things they hated. This nice, innocent, sweethearted, straightforward American trying to protect his community, but not try to cause any harm, who wanted to bridge the gap between people. And instead, what they did is they wanted to kill him for it. And they want to pretend that they're going to get it. There's people that are going to get on the stand. They're going to try to lie. My advice to all of them is don't do it. Assume that whatever you think nobody knows is known, because it is known. We have had a big investigative team on this case. And so people who have made statements that they think nobody's ever going to find, nobody's ever going to catch. Some of them want the judge to not disclose their name to the public because they're hoping they can hide their lies behind anonymity. Ain't going to work. So if they're smart, they don't commit perjury on top of anything else and testify honestly. And if they don't, they will get caught and it will be shown to the jury.
And not that, look, ordinarily you don't victimize the alleged victims. In this particular case, the people who got shot were very unique three characters. One had some serious, was on a suicide mission, apparently. You'll correct me if I'm wrong, Robert. Another one was a convicted P-word, as we say on the interwebs. And another one was just, I think, the one who literally said he wanted to empty his round into Kyle had he not been shot in the arm, who showed up to the protest with a concealed weapon, not the way, think whatever you think of it, not the way Kyle showed up with his quite clearly visible weapon for the purposes of protecting a business. What do we know of the three victims definitively, not urban legend or rumor-wise?
So two of the people that were shot that night that died, they had long, extensive criminal histories. Now, their criminal histories will not be introduced into trial at this point. If the prosecution, however, because they're careless and they're reckless, may open the door to that history. So we'll see.
How do they do that? I mean, I think I know how, but how do they go about allowing that door to be opened?
A lot of different ways. So in self-defense cases, to the degree you know anyone's history, that can come in. So if for some reason you know their history because of any kind of prior interaction or anything else, that's how it can come in. Otherwise, it only comes in when a prosecution opens the door by trying to claim there are these nice, sweethearted, innocent people who just love protest and wanted nothing to do but protest and had never had done anything bad in their lives, that kind of thing. Then they open the door to be, that's not who these guys are. One of them was running around all night long saying how he wanted to be shot, talking very suicidal, as you mentioned. Another one, both of them that were perished that night both had long criminal histories. And were engaged in extreme violence and intended to engage in extreme violence in their past. And then, of course, the gentleman who's suing the city of Kenosha, who wanted to empty his round into Kyle Rittenhouse, has been telling lies to a lot of people. There's going to be a lot of witnesses get up on the stand to tell lies that will tell fanciful, fantastical stories about Kyle. They might want to think about that FBI video that's out there that shows where they were that night. So, for example, if you're going to get up on that stand and say, I heard Kyle say this and this and this and this, and then we put up the video and the video shows you never were within 100 feet of them, good luck with that perjury. And how long do you think you'll be protected? So I think there'll be a lot of perjured testimony, suborned perjury from the prosecution. And that's the only hurdle we have to overcome, but they'll be effectively cross-examined. And so the key becomes, as long as we get a constitutionally fair jury. And that means they presume Kyle innocent as the law requires, as the Constitution compels. And that will be the biggest, one of the biggest hurdles in the cases. But we're equipping Kyle with the team and the means so that he can have the best possible defense.
And people are rightly noting in the comment section, I should have said victims, because I know all the facts in this as much as they're publicly available now. Those victims were, one of them was firing the gun, from what we've seen from video, to trigger this type of panic. The other one visibly assaulting a dude with a gun with a skateboard. And they could be victims, but deserving victims, and had gotten what they asked for type thing in a bad way. But Robert, okay, so actually for anybody who wants to help Kyle, I guess one question is there a place that people can help, knowing that it's actually going to go to help Kyle and not others?
Yeah, so the main site for that is freekyleusa.com. I'm going to be putting up stuff on our locals page, vivabarneslaw.locals.com, to give people leads. In addition, there's another group that's setting up an independent website for where people will be able to go as a one-stop shop to find out all the information they need to know concerning the case, to stay informed, to stay apprised, because we know the media won't provide honest coverage. Because one thing that's important that people need to understand is it's not only about getting acquitted in court. You need to protect a client's public reputation so he's not destroyed afterwards. Ask George Zimmerman. I mean, George Zimmerman won in court. He had his life destroyed. He hasn't been able to meaningfully put it together since then. And so that's true for many people that have, whatever you think about O.J. Simpson, he was acquitted. Didn't help him in the court of public opinion because people came to convict him in the court of public opinion, no matter what the jury did.
And they convicted him in another case, probably because they thought he was guilty in the first case. Question about Kyle that I just had, which was, yes, is the trial, someone had asked, is the trial going to be broadcast the same way Chauvin's was?
Yes, Court TV. So Court TV will be broadcasting it. There's a bunch of people. There's some media and crew, and there's some places. But you'll be able to watch it from gavel to gavel every day. The jury selection will start Monday. You won't see the jury, obviously, but once throughout the trial, you'll never see the jury or the people being picked for the jury, but you'll see everybody else, the witnesses, the judge. Now, the prosecution has asked the judge. There's a couple of our witnesses that don't want the world to know who they are. It's supposedly for safety purposes. I don't think so. I think it's some witnesses who don't want people to know. Hold on a second. I know George. That was the guy that lied about or he's lying right now.
Perfect timing. I bring this one up. Eggplant Barnes. How will you defend against what happened with Chauvin activists lying to the jury? I mean, exactly. Activist witnesses will be more of the issue this time as it relates to what we're talking about now. But they don't want the public seeing their face. They don't want the aggregate knowledge of the internet finding out who they are to maybe prove what they're saying on the stand is wrong.
Well, and that's why, any good defense work, you prepare in advance everything you find out about. You have a highly sophisticated forensic investigative crew that does detailed research and review. And other people have been responsible for that in this case, but I'm confident that they've done so. And then on top of that, in terms of jury selection, we're bringing in people to make sure that people are not able to lie to falsely get on the jury. And I've been doing this for 20 years. And so we're confident in the team. And this will be the best jury selection team made available to Kyle in the history of criminal cases in the United States. That's who we put together. Some fantastic people who've been very generous with their time. Many of them are doing this without any advance payment at all. Some are coming in on their own dime and their own time. I'm covering for some other folks. But it's a fantastic team of people who understand that Kyle's case is much bigger than Kyle. This isn't just about an innocent kid getting fair justice and the innocence that he deserves and recognized in court, but it's about the right of self-defense, period. Because if Kyle Rittenhouse can go to prison, all of us tomorrow can go to prison, and self-defense is dead in America.
People are just going to say, well, all you have to do not to have this issue is don't show up anywhere with a firearm. But the question is, I mean, we're seeing it in other cases, similar prosecution. Incidentally, what is going on with Strickland? Has there been any update with Michael Strickland?
No, I mean, the U.S. Supreme Court never took the case, unfortunately. Okay. We'll see if they someday step in. Now, they do have a lot of good Second Amendment cases coming up.
The one out of New York, for example?
Yes, oral argument, I think, is next week or the week after. And so there's a long litany of good I think they have 3 other big Second Amendment cases coming up. And I think the Supreme Court will expand the right of the Second Amendment across the board. And hopefully they will embrace the right to self-defense as part of that. Now, in Wisconsin, a lot of good law is here. So unlike Oregon, where the law has got really squirrely, but in Wisconsin, it's still pretty good because it's still fundamentally a blue-collar state and a populist state in terms of its political predilections outside of the Communist Republic of Madison.
All right. I thought you were going to say Canada for a second, but but Robert, actually, and just so anybody who doesn't know, Michael Strickland is the journalist who pulled a weapon while being literally chased and threatened and assaulted by a gang of angry individuals. So the Supreme Court did not take up his case, which means he's served his full punishment. So it was more.
Oh yeah, I mean the advantage we won on the set. We were hired after the case. We were hired at the sentencing stage. We weren't hired before that. Unfortunately, it would have been fun to have been part of the case. I think we would have got a different outcome. But that ship had sailed by that point. The sentencing outcome was a very light sentence by traditional terms, so that he wasn't facing any additional prison time or jail time. And so that was, and again, people can follow him at Laugh at Libs, I think is his channel. Funny guy, interesting guy, and he was the canary in the coal mine on how various Soros-style prosecutors were going to come for self-defense and try to strip us of our right of self-defense, and as to the threat we face in the public or from the state potentially. Second Amendment is self-defense in general. And so it was in credit to him, because he could have just stayed quiet, played nice. Instead, he raised the issue somewhat to his own personal detriment. And that's where Kyle's case is so significant, because they're accelerating. And I mean, he faces life in prison. Yeah, that's what people need to know. He faces life in prison.
One more question on Kyle after this, but the New York case is the what is it? NRASP versus whoever the individual that offers licenses for firearms in New York. That case is addressing whether or not the right of self-defense as proclaimed under Heller extends beyond the home. And so the Supreme Court did take that one up?
Yes. And in fact, I think they took up 3 others as well. Okay. I think they're going to clarify that the Second Amendment goes past the home, that the Second Amendment, it does incorporate everything related to the self-defense. And I think the theory that I raised on behalf of Strickland before the U.S. Supreme Court, that the U.S. Supreme Court didn't ultimately take, I think you're going to see that show up in one of these decisions. And so I tell people, even I know it's a long shot to take a case up to the U.S. Supreme Court. It's a lot of work, and you have to print all these little petitions, and you got to pay like $5,000 just to print them for the judges and all that jazz. But it's useful because you're educating them on an important issue. It's not very often you get to say hi to 9 Supreme Court justices and 36 law clerks that work for them. Law clerks are going to go on to be professors and judges themselves. So, and the fact that we made those arguments, and now we're seeing those arguments echoed in cases they're actually taking, is a reason why you always push it, even if it's a long shot for your case itself to be taken.
Now, there was a 99-cent super chat. Now, it was a super sticker, fire starter. I thought it said something farter, which is why I was going to try to bring it up. I couldn't bring it up. So, okay, what else do we want to know about Kyle? Anyone slap in some questions right now if we didn't address anything on the latest updates in Kyle? Okay, I mean, we're going to see this in real time, so we'll know what strategy ultimately is adopted by the defense as this trial gets going.
Exactly. I mean, in a week, one way or the other, we'll see. I mean, my job is to give Kyle all the best options. What he does with it is always his. I'm a strong believer in client empowerment, not to force things on clients, not to coerce them into things, to say, here's your options, here's why I think they're a good idea. And it's up to him where he wants to go. But my job is to make sure he has the best possible options available to him. And I've delivered on that, and we'll be delivering on that. And hopefully we'll get to march forward together to see full acquittals for him. All
right. And now the prosecutor, that was the last question I had. Is the prosecutor still on the file?
Oh, yes. Same guy. Mr. Binger, I believe his last name is. He seems to fix his hair a lot. He's one of those. He's a politician in disguise as a lawyer. And I think he's deliberately said a lot of false things in court to inflame the court of public opinion, to where a lot of people think they know things about Kyle that they're wrong about. Kyle was never part of any militia. Kyle's never had a racist bone in his body. Kyle's never been, he didn't go there for any vigilante purpose. He went there to try to protect people and to help people. He's someone who split time deciding, am I going to be a nurse or am I going to be a police officer? That's the kind of guy he is. The people who want authority and all the rest, they don't think about being nurses. That's who he is. That's what his mother was, an 80-hour work kind of person. So he's got sisters and siblings that have been threatened through all of this nonsense. So he was just a kid who tried to defend and protect people from more harm. Because I mean, you drive around Kenosha, there's buildings still that still have boarded up. Right. I mean, this was an attack on Middle America by a bunch of Antifa radicals, and this was a kid who was just trying to keep people safe and keep people well off. And because that very fact enraged the sociopathic criminal elements in the audience, so much so that the prosecutor is begging the judge to say, please don't let the defense talk about rioters. Please don't let them use even the word rioter. Don't let them use the word looter. Don't let them use the word arsonist. Please rig this case in the way that the prosecutor is trying to rig it in the court of public opinion. I don't think that's going to be successful. This court has been diligently fair, dedicated to making it as apolitical as possible. making sure we do get a constitutionally fair jury. He's made that clear, so that we'll get enough information and questions so that we can make sure people don't get on the jury like the Chauvin jury, who already had convicted the defendant before the trial. And all we want is that people that presume him innocent to be the only 12 people in that box. And as long as we get that, Kyle will be acquitted because the facts will set him free.
Now, two questions without going into specific strategy. We've discussed it before, but will he testify? What's your overall opinion without necessarily strategically speaking on this?
That's always a defendant's choice. So under the Constitution, there's certain choices that are given to the lawyer, tactical choices. But one of them is not whether the defendant testifies. Whether the defendant testifies is solely or wholly the choice of the defendant. Now, what they are told with the jury instructions is they cannot use that against him. Prosecution, if he chooses not to testify, the prosecution cannot even reference it in their closing argument. Now, this prosecutor seems to have a moral compass that was broken from birth, so we'll see what he does. But, so it's entirely up to Kyle. And I think usually in these kind of cases, a defendant waits to see what happens at trial before they make that decision. So, he's someone who is extraordinarily innocent, and that comes through in his testimony. So from that perspective, there'd be arguments for his testimony. My general view is for defendants, if you like to structure your case so that the defendant does not need to testify. You make it ancillary. In other words, you use the government's own evidence, the government's own witnesses to prove your case, because that's even more powerful. And I believe there's an opportunity for that to happen here too. But ultimately, that's entirely a choice that Kyle Rittenhouse himself makes. And your job as a lawyer is to give him the best information. Here's why we think it could help. Here's where we think it could hurt. Here's what your risks are. Here's what your upsides are. But ideally, I think the video is so clear that he won't have to testify. But it'll be up to him whether he wants to or not, given the lies that have been told about him for a year.
And I guess one more question before we wind this one up until next week. Do you know how he's doing psychologically? I think it was, let me see if I can find the chat. Oh, no. Does Kyle have Hispanic heritage? Do you know if he has Hispanic heritage, Robert?
Yeah, he has mixed race relatives. Absolutely. So and that's where like the idea that he's racist is insane. And they know that's not true. In fact, it was one of the people that he had to defend himself against, defend the community against that night, who was out saying racist things. People can find the language he was using. That was the person dropping certain words, not Kyle Rittenhouse. And so, they did a colonoscopic review of his social media and found nothing, found nada, zero, zilch, zunka. And so he should be acquitted. We'll see how it ultimately, my job is just to give him all the best options he can, give him all the best tools in the toolbox for him to use. And it's up to him what he wants to do with it.